Hey everybody, this is Advocate Lucinda, your empowerment lawyer. You know, it is difficult to ask a judge to recuse himself or herself, not only for the judge, but for the person making the request. But sometimes it is necessary. Why? To preserve due process. And that's what we are going to talk about today. The motion to recuse a judge based on bias and prejudice. And we're going to look at some examples of what bias and prejudice is. And we're going to talk about the filing requirements to file a motion for recusal. Now, before we get started, let me be clear. This is not an indictment on judges. There are wonderful judges out there. I have practiced before many wonderful judges. My colleagues speak about wonderful judges that they go before. But unfortunately, there are judges who do not follow the rules, who are biased and prejudiced. We're thankful for judges, and our hats off to those judges who really make a good faith effort to adjudicate. Thank you. Let's get started. 28 U.S.C. Code Section 455 addresses the disqualification of the justice, judge, or magistrate judge. Pursuant to the Due Process Clause of the United States Constitution, judges are required to recuse themselves from cases in two situations. One, in any proceeding in which the judge's impartiality might be reasonably questioned. And you can read that specifically in 28 U.S.C. Code Section 455A. And two, where there is otherwise a strong possibility that the judge's decision will be biased or he or she is prejudiced. And you can go to the same code, but subsection B. So let's do a little test here and see if we can identify bias or prejudice of a judge. True or false? The fact that a party to a case is an attorney who may have previously had cases before the court is sufficient to create a question of partiality or bias. True or false? What do you think? That is false. Jorgensen versus Cassidy, holding that recusal was not warranted even though the plaintiff was a former law clerk of the presiding judge. An allegation by the same plaintiff that the same judge ruled against him in a case 10 years ago isn't sufficient to create a question of partiality or bias. What do you say? It's false. An adverse ruling against a party do not in themselves provide a basis for disqualification. And I've given you a case here, United States versus Hines. An allegation by the party that the judge would make inappropriate humor and frivolous and often demeaning dialogue against the plaintiff. Is that sufficient to create a question of partiality or bias? True. In this case, and I blocked out the judge's name because I'm not about trying to shame anyone. We're doing this for informational purposes and to empower you. But in this case, after the panel reviewed the allegations, they found that the judge engaged in voluminous violations of the rules governing the conduct of Ohio judges and of lawyers, including rules requiring judges to act at all times to promote public confidence in the judiciary's independence, integrity, and impartiality, to uphold and apply the law, and to be patient, dignified, and courteous to those the judge deals with in an official capacity. What are we saying? A mouthful, obviously, but I think you get the point of the requirement of judges to act in a way that they are not biased or prejudiced. And that could mean many things. Only the party be able to identify those specific acts. An allegation by the party that the judge engaged in improper ex parte communications and violated her duties to remain impartial. This is true. The court found that this particular judge engaged in a series of transgressions that violated provisions of the Code of Judicial Conduct and the Code of Professional Responsibility, including ex parte communications. Now, a plaintiff can also, or defendant for that matter, can also use 28 U.S. Code Section 144 to recuse a judge based on bias or prejudice. The code section states in part, whenever a party to any proceeding in a district court makes and files a timely and sufficient affidavit that the judge before whom the matter is pending has a personal bias or prejudice either against him or in favor of any adverse party, such judge shall proceed no further therein. So the judge needs to automatically recuse himself or herself, and another judge shall be assigned. But notice here, the party who is requesting the judge to be removed must file the affidavit with its motion. I will be placing a link in the description page of this video. It will be a sample motion for recusal or motion to recuse. But let me say this. Be sure to read the code sections 455 and 144 that we just went over, and particularly 455, because it gives you a list of things that would require a judge to recuse himself or herself. So it's important that you read those, and also always read local rules. That's important. I trust this video has helped you, and I want you to be encouraged, and I want you to be empowered. Until next time, take care.